Good day, everybody. Here we are, the Theogenic Esquire podcast YouTube channel. This is my second live stream. I did my first yesterday. We talked about some of the kind of core fundamental concepts of defamation law in the context of the recently dispatched cease and desist letters from TPUSA. One to Wolves in Finance, one to Candace. And so we covered that. We did get cut off. I came back on there for just a little bit and tried to, hey, Susan, how you doing? Yeah, you are on time today. Yay. And so I came back and I actually, even after I, rehabbed, I actually did a really quick, like 5-minute summary video just to hit all the high points. So I hope y'all who are interested were able to check that out. So today, if we get cut off, look, the weather's, we're here on the East Coast. The weather's kind of crazy. If we get cut off, what I'm going to do is just do that summary video. And I might do a summary video anyways, just because I think it's great for y'all to have like access to like a ready summary. That way, if you want a refresher, anything like that. And then today I'll do a little bit of looking at the comments while I do like the main lesson, but I'm going to kind of like everybody else does, save most of the question and answer for the end. So thank y'all for sticking with me. I'll try to get through the main lesson kind of quick. I'm going to try to keep this less than an hour today. But today we're going to be discussing, I did a video the other day called Covering the Cover-Up, and we're basically looking at the covering up, literally, of the crime scene at UVU. I think a lot of people, non-lawyers for sure, that were offended by that, right? I mean, just our pop culture, watching these crime shows, stuff like that, people know how really in a lot of ways sacred those crime scenes are, right? Because that is where the rubber meets the road. That's where the experts, hey, what's up, Lisette? Glad to have you. That's where the experts really can get in and do their work. And so what we're going to do today, so my first video, right, I just kind of generally introduce the fact to everybody that, hey, normally the state, the government can't just get away with this, right? We have rights, due process rights, which, impart certain duties upon both the state and the defendant, right? So it very well could have been. And if we look, this kind of grinding my gears, to be quite honest. I've been looking back over the information, the indictment, essentially. And I'm doing this in advance because we're going to do another live stream where we actually analyze the facts and stuff under the legal framework we're going to talk today. So today is just a discussion setting up the due process analytical framework under Article 1, Section 7 of the Utah Constitution. And we'll do a little bit of chatting about what's happened in this case, stuff like that. But we're really going to save like the deep roll up our sleeves analysis, trying to figure out like kind of how would the court come out. Hey, good afternoon. How you doing? We'll do a second separate episode where we actually like do an analysis, and hopefully as a group, as a community, we can kind of come up with, what our idea of how the judge should rule on it. Okay. So again, we're going to split these up, but today we're going to be just talking about what do the Utah courts look at? What is oh yeah. Hey, Susan, thank you. Yeah. Like, share, comment. I'm like 5 followers away from 500 today. Yay. So hopefully we can get to that number today. That'd be awesome. And we'll keep it going. But yeah, back to where I was. So yeah, today we're going to set up the analysis. We'll do a second one where we, actually dig in. And to be honest, I'm still digging up some materials. I'm going back over the information, getting everything in alignment, because here's what happened. We have the information. Really, we're going to be mostly do our analysis based on what's in there and stuff. But as y'all know, all these other factoids and, they disclosed this day, they said this on camera that we tried. So it's been kind of confusing to me. So I'm kind of doing a reset and getting back into a firm grasp of like, what are the facts that the state's alleging that, that's in the public right now that, that they're putting out there and they have to stand by it. So that's what we're going to center our analysis around. And it sucks because we know that there's other evidence, stuff like that we would for sure need to do the full analysis and would be very helpful. And plus we're just curious, but we're going to do the best that we can. What you're going to find today on this lesson is that the Utah courts are very forgiving. Not I say forgiving. They're actually, in my opinion, very defense friendly in these kind of scenarios, in that, as we'll see, it doesn't require that the state intentionally or maliciously destroy these things. Obviously, it is a factor, kind of their level of culpability, but it's not the do all end all. And so with that, ultimately, in my opinion, this is a very favorable legal paradigm for Tyler Robinson to file a motion and be successful. And then we'll talk about what are the potential remedies that the court might be able to fashion, including a potential dismissal. So very exciting stuff here today. I'm glad that y'all could join me. I don't know if y'all saw Wolves and Finance's episode this morning that he did, but he covered the 501c3 political endorsement violations I've been talking about. And so, yeah, it's real and it's blatant. And so thank you, Wolves and Finance, for co-signing my original, what I was pointing out. All good. We're all in this together, right? So anyways, so let's start out. So I got two cases last night after the live stream. I went and pulled two cases that I believe are pretty representative of the jurisprudence of the actual due process standard in Utah. So, and real quick, I'm seeing a comment, and I'm going to try to wait to the end, but I do see a comment, and we're going to talk about this as like, how did this crime scene end up getting paved over? And I think Candace and Barron, I think there might have been another independent investigator that kind of helped too, but they figured out that, in fact, I think it was the state facilities department is the one that ended up putting the order in and getting it done. I think there was money budgeted generally for projects kind of that kind, but there was never like any specific earmarked funds for that specific project. That's just the best of my recollection. Okay. And so again, we pretty sure we have the state, well, it's their property, right? So obviously the state had to be involved some way, somehow in ordering this cover up to happen. So, and we'll get into that in a second, but I can say fairly that in a court, it would be attributable to the state. Obviously, they'd be held to account for what happened there, for sure. What I was saying though, real quick before we hop in, is that they covered up this crime scene. Yet here they are. They got 2 counts in the indictment accusing Tyler Robinson of like destroying evidence because he discarded his clothes, he hid the rifle. He encouraged Lance Twiggs not to talk to police. So it's like they're trying to like get him enhancement, and ultimately, they're also trying to get him the death penalty, like accusing him essentially of like really not as bad a conduct as what they did. Right? The state did recover some stuff that they alleged Tyler Robinson tossed aside. We'll never get back what they paved over theoretically, right? So anyways, that kind of grounded my gears, but let's hop right in. So the first case we're talking about today is a case called State v. Tiedman. I think that's how you pronounce it. This is a 2007 Utah Supreme Court case. Let me read some of the facts real quick. So it's basically like this. Is Tiedman in, I think it was 1991, he was charged with murdering 3 people. He pled guilty by reason of insanity, which was found. So the case was dismissed against him, but he went to the state mental hospital, I think later in like, when was it? Maybe 2000. Let me see real quick. Down here. Yeah, so 2002, he was released from the state mental hospital, and then they recharged him. Well, in that time, they had collected, so when the crime happened, they collected a bunch of like physical evidence. I have 2 revolvers, some kind of kit, a victim's wallet, some non-conducive substances, audio tapes, blood specimen, makeup kit, drug paraphernalia, victim clothes, bone fragments, bullets, bullet fragments. Okay, so they had a lot of physical evidence. Okay, and it was maintained in the, I guess you could say, state's evidence locker. Well, I think it was in 1993, the custodian wrote a letter to investigators and said, hey, I've got this case. We're going to keep it for 30 days. If we don't hear an objection, we're going to destroy it. Well, lo and behold, the investigators, I think in good faith, felt that at the time this case is over, he's in the mental ward, go ahead. So the evidence was destroyed. And then come in 2002, when they tried to recharge him, Tiedman filed a motion to dismiss based upon the destroyed evidence and some Miranda issues as far as his original confessions. We're not going to cover that, obviously, but he did make a bid because of the destroyed evidence. And so the trial court denied his motion and essentially got the test wrong, the legal test. They didn't apply the correct legal test. And so the Utah Supreme Court chimed in, and I guess you could say set the record straight. And so here is what there was a case at this time I think it was out of Arizona, but it's a U.S. Supreme Court case. And under the federal due process constitutional standard, at least at that time, the defendant would have to show that the evidence, no, I take that back. At the time, the defendant would first have to make a showing that the government acted in bad faith. So if it was a negligent or unintentional, or I guess you could say par for the course kind of destruction, kind of like it was in Tiedman, it was protocol that they, sent the letter, waited 30 days, etc. So the federal standard, at least at that time, required bad faith on the part of the state. Now, the Utah Supreme Court, probably the main thing they did here is say that the Utah Constitution does not require bad faith on the part of the state in the destruction of evidence. However, it is a factor. Okay, it is a factor for them to consider. So let's talk real quick. I'm going to read from the opinion and we can see where the standard, we'll know exactly here what standard the Utah Supreme Court came up with for their due process. And then we're going to read another case that clarifies that a little bit. And so then we'll have our standard and we'll do a general discussion on it. So let me read real quick what the Tiedman court said. So they go, in cases where a defendant has shown a reasonable probability that lost or destroyed evidence would be exculpatory, meaning that the evidence has a reasonable probability to have shown my innocence, okay, we find it necessary to require consideration of the following. Okay, so real quick, these cases require an initial showing of the defendant. So in this case, Tyler Robinson would need to show that there is a reasonable probability that the evidence contained at that crime scene that was covered over would have been exculpatory, meaning it would have helped to show his innocence. And we're going to do that analysis, right, next live stream, but just kind of framing it here so that way y'all can start thinking about what this argument might be on behalf of Tyler Robinson's legal defense. Here are the two other inquiries that are pertinent after this initial showing to assessing, one, whether relief is required, and then two, what that relief would be. And it's this. One, the reason for the destruction or loss of the evidence, including the degree of negligence or culpability on the part of the state. So like I said, bad faith or culpability on the part of the state is definitely part of the inquiry. It is relevant, but it's not the do-all, end-all, meaning that if the state did this negligently or it was just normal course of business, you're still in there as a defendant. It's just part of the analysis. Okay, and then two, the degree of prejudice to the defendant in light of the materiality and importance of the missing evidence in the context of the case as a whole, including the strength of the remaining evidence. So here we would look, one, we would need to assess, could Tyler Robinson show a reasonable probability that the evidence covered over could have been exculpatory to his case? If we're in the affirmative there, and it's really just a basic showing, it's just a proffer, as long as it's not, what would you say? Speculation, as long as it's not speculatory and it's pretty concrete, it really just takes a proffer like, hey, judge,